This morning, the spotlight is on the Gilgo Beach serial killer case and a ruling that could affect courtrooms nationwide. Defendant Rex Heuermann appeared in court alongside of his attorney, Michael J. Brown, for Wednesday's court hearing. The ruling allows prosecutors to use so-called advanced DNA evidence against Heuermann, specifically through hairs found on victims that allegedly can tie Heuermann to the crime scenes. Now, Heuermann is accused of murdering 7 women since 1993. The families of some of those victims were in the courtroom, along with Heuermann's ex-wife, Asa Ellerup. Now, Heuermann's defense team has been challenging allowing the DNA to come in, and they're going to challenge the decision the court made yesterday, saying that it violates public health laws because the lab that did the testing isn't even licensed in the state of New York. Let's talk about it some more. Fortunately, we know Michael J. Brown. Let's bring him on in for some questions. All right, Michael, so you, as always, have a backup plan. I think you have backup plans to your backup plans. And so you got this ruling, and then it was, okay, off to the races. You filed your own motion. Tell us what you're doing now.
Well, Julie, we were hopeful that we would get a favorable decision yesterday. We did not. So our backup plan was an additional motion. And this is something we brought up early on with the judge, and he said, well, put it in a separate motion as opposed to the Fry issue. And that's a motion to preclude the evidence simply based on a violation of the public health law. The public health law requires a clinical lab to be permitted, even if you're out of state. It specifically addresses identification procedures, and it specifically says if you're out of state, you can't even receive New York State samples unless you're permitted. And what the public health law does, interestingly, is it actually criminalizes that conduct. It makes it a Class A misdemeanor, which in New York State is punishable by up to 1 year in jail. So this motion now is predicated and focused on the fact that they have violated the public health law. It is criminal activity, and thus it should be precluded from being introduced to trial.
Michael, it's our understanding that this type of evidence that you're fighting over with the prosecution team has never been used before in New York State in a criminal case. Is that correct? That's correct, Julie.
The only case that we're aware of is in Idaho, which is what was called the Dalrymple case. And it was a cold case similar to what we're dealing with. And that's standard. The court did admit that type of evidence. And you have a lot of the same players in terms of the prosecution witnesses, our witnesses. But that standard is not the Fry standard. It's a different standard, and I would suggest it's a lesser, lower standard. But that's the only case that we're aware of where it came in an actual criminal prosecution in our nation.
Wow. Okay. You know, Michael, I know that outside of the courthouse, there were some reports. As you know, this is a very high-profile case. Some reports said that you referred to this type of DNA evidence as magic. Is that accurate? What did you mean by magic?
Yeah, I have been referring to it as magic. The whole genome sequencing, there's 2 components of this, Julie. There's the whole genome sequencing, and once you develop this so-called profile, what are you going to do with it? And that's where it pivots over to the computer program that this Astrea in California does, and the computer program is called the IBD-GEM, and that particular program is what I will continue to call magic. It is highly unreliable. It is based on the Genome 1000 project, which is the alternate suspect pool, which there is no forensic lab that does a evidence sample to suspect sample across our nation. It's unheard of. It's never done. The prosecution's own witnesses said it's never been done, and that's where the magic comes into play, because the actual likelihood ratio, and that's the ultimate thing the prosecutor is trying to do, is throw these numbers before a jury to show them how overwhelming and astounding it is. That's the magic. It's unreliable. It's not credible. But of course, the judge differed.
Speaking of the prosecutor, Michael, I have a direct quote from the prosecutor out of court who said, quote, "We now have nuclear DNA. We have mitochondrial DNA. We have phone records. We have witness statements. We have financial records. We have internet searches. We have phone activity, and we have other evidence as well." Do you agree with that statement?
Well, they have an idea and a notion that they have different parts of evidence that they can introduce, but obviously, that remains to be seen in terms of how credible and accurate these different things are. And really, a jury is going to have to weigh the weight of any of and all of these things. They suggest they have a lot of different pieces of evidence. It's very circumstantial, but when you break down each piece of evidence and dissect it, it's far from strong. And that's why we have trials on the case.
Exactly. Michael, speaking of, is there a firm trial date set yet for this?
No, we haven't even gotten to that, Julie, because the next court date's September 23rd. There's two pending motions still. One is a severance motion because we're trying to separate this indictment from victims and not have everybody tried together, because some of them, quite frankly, should not be tried with the others. And then we have this public health law motion. And there will be subsequent motions in terms of suppression of evidence. But we can't really get to that point until the district attorney's office certifies the case for trial, and then our clock will run and we can go forward with these additional motions.
I got you. So a lot to tackle before any trial date is picked. Michael J. Brown, the best thing going for Rex Heuermann is you. Thank you so much for sharing what you could with us this morning about this recent litigation.